This is the web transmission service of the Royal Canadian Military Institute. On June the 29th, the Defence and Security Studies program of the RCMI hosted a discussion with retired Lieutenant Colonel Rory Fowler, a former legal officer of the Judge Advocate General's Office. Colonel Fowler discussed the topic of addressing sexual misconduct in the Canadian Forces and why various attempts to solve the problem have not worked as they were intended to.
So good evening, everyone. My name is Dr. Daniel Eustace, and I'm the Director of the Defence and Security Studies Program for the Royal Canadian Military Institute in Toronto. And I'd like to welcome you to another event in our series of speakers for the Defence and Security Studies Program. Tonight is the second event we've had in June, but it's one we've been looking forward to for some time. As you know, tonight's subject is on addressing sexual misconduct in the Canadian Armed Forces. And before I introduce our speaker, Lieutenant Colonel Rory Fowler, retired, I just thought I'd make a couple of preliminary remarks to sort of set the stage for this presentation. I mean, one question that may come to mind for people is why would the RCMI be presenting this particular topic at this particular time? I mean, the obvious answer is what's going on in the news. In fact, we have addressed this issue previously in a co-designed conference we ran in 2018 with Women in International Security. It was a well-attended conference, and we had an entire panel devoted to that subject, and we learned a great deal. So I do understand, though, that some people might ask the question, why would the RCMI feel that this is the right venue to discuss this issue? I know from my own experience when I joined the RCMI back in, yes, believe it or not, 1987, there was still, although the policy had not been enforced for some time, there was still a plaque above the entranceway to the long bar which said, members and male guests only. I think it had been left up there as a kind of, I don't know, a reminder of days gone by. But the RCMI has certainly evolved a great deal in the past 30 years, and so this is a subject that is of great significance to the Canadian Armed Forces and national security. In my own experience outside of the RCMI, I still instruct for the Canadian Forces College, and the course that I just finished recently for the Joint Command and Staff program was called Institutional Policy Studies. And the centerpiece of that program was a 3-part case study on this very subject. And so I had 22 majors and lieutenant commanders and lieutenant colonels writing about this subject in great detail. And for their final papers, several of them submitted papers on various aspects of this subject. And 3 of them were really quite outstanding, and I will be publishing those in our next edition of SITREP to give you a perspective of some serving officers, male and female, who have really, really good ideas, not only about the causes of this issue, but some of the potential solutions. So I do think, because this is a subject that is directly related to the governance of the Canadian Armed Forces, it relates to national security. It has been identified as such by the Acting Chief of the Defence Staff as being a critical subject that must be addressed. I think it's very appropriate for the RCMI and the Defence and Security Studies program to be addressing this issue right at this particular moment in time. Let me just outline a couple of rules of engagement. At the beginning of this, you saw that the presentation by our speaker, who I'll introduce momentarily, is being recorded. At the end of his presentation, our intent is, and we will turn off the recording function so that the Q&A session will be Chatham House rules. You can feel free to ask any question or make any commentary that you wish, and that will not be recorded. So I hope that that will contribute to our discussion near the end of the presentation. We're going to leave the chat function open for you to use throughout the presentation. The Q&A function is there for you if you wish to submit questions in writing. And when we get to the actual Q&A session, the raise hand function will also be available for you so that we can turn to you and you can ask your question verbally if you would prefer to do it that way. So we want to encourage as much discussion as possible. Of course, all discussion is assumed to be respectful and in keeping with the propriety that such an event would anticipate. So I look forward to this very, very much. Now, let me turn to our speaker. Lieutenant Colonel Rory Fowler retired from the Canadian Forces after having served for nearly 28 years, first as an infantry officer with the PPCLI, and then as a legal officer with the JAG, Judd Advocate General. And during this latter role, he worked extensively in the area of public administrative law as both a legal advisor and educator. And among other positions, he served as the Director of Law, Compensation, Benefits, Pensions, and Estates, and the Director of Law, Administrative Law. Now, throughout his service, Rory has developed a keen interest in the nature of the Crown-soldier relationship, including how it was distinguishable from more traditional employment paradigms, and how this unique constitutional and statutory relationship could be better explained and understood. His interest in this subject is driven by a desire to ensure that the governance of the Canadian Forces reflects a just and fair approach to decision-making and complies with the rule of law, in order that the discipline, efficiency, and morale of the Canadian Armed Forces support its overall operational effectiveness. Despite the significant and far-reaching impact of statutory decision-making within the Canadian Forces, legal theory of this unique relationship has not been subject, or has been subject of limited scholarship and not well understood by the statutory actors who wield significant power within the governance regime. And Rory's intent is to improve this understanding through his ongoing research at Queen's University here in Kingston. Finally, I would say that since embarking in private practice in 2017, national television, radio, and print media often call upon him for commentary on legal issues pertaining to the Canadian Armed Forces and military law generally. And of course, that is why we are pleased to invite him here to speak to you members and guests of the Royal Canadian Military Institute this evening. So with that, let me turn to Rory and thank him for taking the time this evening to come and talk to us. We look forward to your presentation, and we look forward to the question and answer period following. So Rory, over to you. Thank you very much.
Thanks very much, Dan. And we'll start right off the bat, folks, with our PowerPoint presentation. And one of the things I want to make clear right from the outset, I might disappoint some of you, because if you were tuning in because you figured I'd be offering the answers to addressing sexual misconduct in Canadian Forces, I'm going to disappoint you, because the answers are nowhere near as simple as some people might have us believe. And rather than provide what some people might construe as being the answers, what I'm going to provide is some commentary on what the answers probably are not. And therefore, by a process of deduction, we can determine what the answers should be. The topics of discussion are up in front of you there. One of the things that I'll make clear from the outset is, before we start talking about sexual misconduct, and before we start talking about what potential solutions for sexual misconduct might be for the Canadian Forces, we're going to have to first discuss what the background of the governance of the Canadian Forces is, and that'll help us determine what those solutions ought to be. And Dan, I'm actually going to ask, is everyone seeing everything? Because I'm getting some error messages.
Rory, I'm seeing your main slide here, but I'm also seeing some other stuff on the screen, like a Zoom thing. That looks okay to me right now.
Okay. It looks like I'm getting some error messages, but we should be okay then. So before we get into the solutions, or before we get into discussing the very specific issue of sexual misconduct, we're first going to talk about the background and first principles when it comes to the governance of the Canadian Forces. That will then allow us to discuss in greater detail the roles and responsibilities that we'll encounter from various statutory actors and statutory decision makers, and it'll allow us to place in context what potential solutions to sexual misconduct, and indeed misconduct generally, might be for the Canadian Forces. So the first principle I want to talk about is the rule of law. And this is something that anyone who follows my blog or anyone who follows my commentary will probably be familiar with, because I mention rule of law quite frequently. Now, the rule of law that I tend to espouse is the rule of law that Lon Fuller discussed in his 1964 foundational work, The Morality of Law, which deals with the rule of law as a fundamental principle of a democracy. It is not synonymous with all laws must be followed. That's not what is understood as the rule of law. Rather, Fuller talks about 8 specific principles that deal with the rule of law as a principle of democracy, as a foundational principle of democracy. And it is those principles that I base a lot of my research on, and it's those principles that I base a lot of my commentary on. And the other thing that is going to crop up in our discussion this evening repeatedly is the nature of statutory decision making. And whenever I speak to groups of new legal officers, groups of senior officers, even groups of junior officers or non-commissioned members, one of the questions that I always pose to them is, how many statutory decision makers are there in the Canadian Forces? And I'll let you in on a little secret, because most people get that wrong. And so if you ever hear the question, how many statutory decision makers are there in the Canadian Forces? What I'd suggest to you all is that there are over 100,000 statutory decision makers in the Canadian Forces, because everybody, every member of the Canadian Forces who makes a decision is likely doing so under a statutory regime. It might not be expressly laid out in a statute, but it is going to be something that is going to be traced back to a statute, and almost invariably that's going to be the National Defence Act. So when we talk about the Crown-Soldier relationship, some of you might be familiar with the expression that members of the Canadian Forces are in a unilateral arrangement for the sole benefit of the Crown, in return for which Her Majesty assumes no obligations. Now, that quote is drawn from a 1978 case of Gallant and the Queen. But Gallant and the Queen was not the origin of that principle. That can be traced back to an 1896 case called Dunn and the Queen, and that comes from the Court of Appeal for England and Wales, in which the Master of the Rolls, who is the senior judge of the Court of Appeal of England and Wales for civil matters, held that a member of what we would now call the public administration, but a member of the civil service, is not in privity of contract with the Crown, but is instead in a non-contractual relationship, in return for which that individual cannot seek remedy before the ordinary courts. And in fact, in Dunn and the Queen, they drew upon an earlier case, and you'll see it up there on the screen, and it's cited as being 1896, but in fact, the case of Mitchell and the Queen was decided earlier in 1890 by the Court of Appeal for England and Wales. And again, Lord Esher, the Master of the Rolls, was involved in that case. And that involved somebody not unlike myself, a retired lieutenant colonel, who was trying to sue Her Majesty in the civil courts for a pension. And the principle that was espoused in Mitchell and the Queen, which was then repeated in Dunn and the Queen and subsequently in Gallant and the Queen in Canadian jurisprudence, was that there were 2 fundamental principles that governed the Crown-Soldier relationship. First, it is not a contractual relationship. And secondly, that it is a relationship for which the individual cannot seek a remedy before the civil courts. And that, since 1978, has been repeated time and again in Canadian courts, particularly the Federal Court and Federal Court of Appeal. And I would actually suggest to all of you this evening that, in fact, those principles are not precisely still intact, because anyone who follows the news will probably be aware of certain circumstances in which members of the Canadian Forces have in fact successfully obtained a remedy before the civil courts. So one of the principles from Gallant and the Queen, that a member of the Canadian Forces cannot seek a remedy in terms of the crown-soldier relationship in the civil courts is just fundamentally not correct anymore. But the enduring principle that the relationship is not governed by contract, in other words, it is not governed predominantly by private law, remains intact. And that relationship remains firmly rooted both in statutory as well as constitutional principles. It is, at its heart, a public law relationship. And that makes it distinct from any other employment relationship, including the employment relationship of first responders like firefighters and police officers. And the other principle that I want everyone to bear in mind as we move forward this evening is a principle that was espoused in the Queen and Genereux in 1992, and again was reiterated more recently in the Queen and Stillman in 2019 before the Supreme Court of Canada. And that is that the Code of Service Discipline exists to allow the chain of command to maintain the discipline, efficiency, and morale of the Canadian Forces. And what's particularly interesting about the Genereux case is that principle, even though Genereux is repeatedly cited, most often by the Office of the Judge Advocate General, even though Genereux is repeatedly cited for the principle that the Code of Service Discipline is a justifiable derogation from the ordinary criminal courts in order to permit the chain of command to maintain the discipline, efficiency, and morale of the Canadian Forces, that principle was not actually at issue. It was not contested in Genereux. Rather, in Genereux, what was being contested was whether or not general courts-martial, as they existed in the early 90s, were sufficiently independent and impartial to serve their function. And the reality is, in Genereux, the majority of the Supreme Court of Canada, all but one dissent from Justice Larouche-Bay, held that, in fact, general courts-martial of the day were not sufficiently independent and impartial to serve their functions. And so one of the issues that we're going to be talking about this evening quite clearly when we're talking about addressing sexual misconduct is the role of the Code of Service Discipline and the role of military justice writ large. And I would suggest to you that one of the problems that we often encounter is the definition of military justice. The received wisdom of the Office of the Judge Advocate General is that military justice essentially equates to the Code of Service Discipline. I, however, take a much broader approach to the definition of military justice, and we will be returning to that definition in a few moments. But I take the approach that the definition of military justice must necessarily be broader than simply the Code of Service Discipline. And the reason that that is important is because the Judge Advocate General, under Section 9.2 of the National Defense Act, has a very specific statutory role in superintending military justice. That is the term of art that is used in the National Defense Act. And if, in fact, military justice means more than the Code of Service Discipline, then necessarily the Judge Advocate General must superintend more than just the Code of Service Discipline. And it's pertinent in particular because it was just announced today that Rear Admiral Bernatchez, the Judge Advocate General of the Canadian Forces, has just been renewed for an additional 2 years for her term as the JAG. And the last thing we're going to be talking about foundational and background principles is the nature of legislative reform. And we'll turn to that now. Legislative reform is an ongoing process, not just for the Canadian Forces, but for, in fact, any function of government. But in particular, what I'd like to point out to all of you this evening is that most frequently, legislative reform arises in the context of the Canadian Forces, typically as a result of successful applications or appeals by those members of the Canadian Forces who are subject to the rather coercive nature of the Code of Service Discipline in particular. And you'll see up there a list of various legislation and legislative reform that's been introduced over the past 20-25 years. One of the big changes was Bill C-25 in 1998, and that was heavily influenced by the Genereux decision that I mentioned previously. Additionally, Bill C-60 in 2008 was influenced significantly by the Court-Martial Appeal Court of Canada decision in the Queen and Trepanier, which dealt with whether or not the accused was going to be permitted to select trial by a particular type of court-martial, and Bill C-16, which was heavily influenced by the 2011 decision in the Queen and LeBlanc. In both Trepanier and LeBlanc, the applicant or appellant of who was essentially the accused was successful before the court-martial appeal court. An appeal was not permitted to the Supreme Court of Canada in either of those cases, and as a result, that triggered additional legislative reform by the government. And so the lessons that we learn from Bill C-25, Bill C-60, Bill C-16 is that more often than not, legislative reform of the Code of Service Discipline, and in fact, legislative reform of the governance of the Canadian Forces, is most frequently driven by successful applications or appeals by individual members of the Canadian Forces. The most recent change, or the most recent reform, was introduced in 2019 with Bill C-77, which was enacted in 2019, but most of which has not yet come into force. And the two big subjects of Bill C-77 were the introduction of a Victims' Bill of Rights, which had already been introduced in the ordinary criminal code, as well as the introduction of summary hearings as a replacement for summary trials. And most of those provisions have not yet come into force, including the new definitions, such as the definition of military justice. And you'll recall earlier I'd mentioned that I take a much more expansive approach to military justice than the Judge Advocate General does. The reality is military justice is defined in Bill C-77 as being the Code of Service Discipline. So because that issue has been contentious for over 20 years, now they're in effect retconning the definition of military justice by indicating that military justice is essentially the equivalent of the Code of Service Discipline. That does raise concerns for me, because if in fact all military justice means is the Code of Service Discipline, then why didn't Section 9.2 of the National Defense Act simply make the Judge Advocate General the superintendent of the Code of Service Discipline? There's a degree of disingenuity in that particular definition, I would suggest. So when we look at Bill C-77, there's been a lot of commentary in the public recently about the fact that victims and complainants in the Code of Service Discipline do not have the same protections as those victims and complainants in the ordinary civilian criminal justice system. I find that problematic because in reality, quite frankly, most of the protections that are available to a victim or complainant in the civilian criminal justice system are in fact already available to complainants and victims in the Code of Service Discipline. And even though some of those benefits and protections have not necessarily been enacted in statute, they are still extended to victims and complainants in the process of the Code of Service Discipline. In particular, one issue that's been raised repeatedly by certain academics, for example, is the use of what are called O'Connor applications. And these are applications essentially under the criminal code by which an accused can seek disclosure of third-party documents. When it comes to prosecutions for sexual assault and sexual misconduct, quite often these are records that are held by the complainant herself or himself. And the reality is, even though some commentators have suggested that victims and complainants in the Code of Service Discipline do not have the protections that they would have in the civilian justice system when it comes to O'Connor applications, they do in fact have those protections under the Code of Service Discipline. That's actually been recently tested in a case this year, the Queen and Tate, from this year, a court-martial. And not only are complainants and victims in Code of Service Discipline proceedings permitted to have representation in the stage 2 of an O'Connor application, but on top of that, under the Treasury Board policy for legal assistance and indemnification, complainants and victims are actually entitled to representation at Crown expense. And so it does tend to bother me a little bit when people suggest that there are certain protections that are not available under the Code of Service Discipline when those protections are, quite frankly, available. The other thing that was introduced in Bill C-77 was the new concept of a summary hearing. Now, the summary hearings are predicated upon, in principle, the same sort of principles that drive self-governing professions, like doctors or lawyers, for example. And two of the key provisions, when the summary hearing provisions do in fact come into force, that will be enshrined within statute, within the National Defense Act, is that somebody accused of a code of service discipline infraction that's going to be tried by summary hearing will not have a right to elect trial by court-martial and will be subject to a lower burden of proof. So frankly, in my view, the introduction of summary hearings, when and if they actually come into force, is principally designed to make it easier to get convictions. Now, these are allegedly predicated upon professional regulation or self-governing professions. But I find that a disingenuous basis for presenting summary hearings, because quite frankly, members of the Canadian Forces are not the same as self-governing professions. They do not choose the people who represent them. They do not choose the rules to which they are subject, unlike, for example, lawyers like myself, who are subject to self-governing provisions. Now, that's a little bit of the background of the governance of the Crown-Soldier relationship, and quite frankly, it was pretty rapid fire. We'll now turn to sexual misconduct. Now, most of us are probably very familiar with the Deschamps report that was ordered in 2000. Well, it was ordered before 2015, but was delivered in 2015. The challenge that the Canadian Forces had was in implementing all of the recommendations from Justice Deschamps. And you'll recall, many of you will probably recall, that the Chief of the Defense Staff at the time acknowledged and accepted, quote, in principle, all of the recommendations. There's been a fair bit of commentary on the Deschamps report, and I'm not going to delve into that in too much detail. What I will focus on is the fact that, for whatever reason, the Defense Administrative Order and Directive 5019-5 that dealt with sexual misconduct was canceled in late 2020 and was replaced by DEOD 9005-1, which was the sexual misconduct response. It is that DEOD that defines sexual misconduct, and sexual misconduct is actually given an extremely broad definition. It is conduct of a sexual nature that causes or could cause harm to others, and that the person knew or ought reasonably to have known could cause harm, including, and it lists a shopping list of potential misconduct that is not limited to simply criminal code misconduct or even code of service discipline offenses. However, by creating a DEOD that prohibits certain conduct, as we all know, that inherently creates the possibility of charging an individual under Section 129 of the National Defense Act. But one question I would have for all of you to think about this evening as we discuss this issue is, how does sexual misconduct differ from other forms of misconduct? And I would suggest, in the context of the Canadian Forces, while sexual misconduct is in fact a particularly problematic type of misconduct, at its core, it needs to be addressed for the same fundamental reasons as any other form of misconduct in the Canadian Forces, because it potentially adversely affects the discipline, cohesion, morale, and efficiency of the Canadian Forces. And part of the problem I would suggest that we encounter in coming to terms with a solution for sexual misconduct is we tend to characterize it as a fundamentally different type of misconduct, and therefore requires fundamentally different answers. But in reality, if we turn back to what was said in Genereux, what the late Chief Justice Lemaire defined as the rationale behind why the Canadian Forces is permitted to maintain a separate system of the Code of Service Discipline as a derogation from the civilian criminal justice system in order to maintain the discipline, efficiency, and morale of the Canadian Forces, then what we have to come to terms with is the fact that the main reason that we would want to address sexual misconduct in terms of the Canadian Forces is because it adversely affects discipline, efficiency, and morale. And therefore, at its root, even though the specific nature of the misconduct might be different than other forms of misconduct, what we are attempting to achieve in addressing sexual misconduct is essentially the same outcomes that we attempt to achieve with any form of misconduct. I turn now to Op Honor, which was the initial response to the Deschamps report and the issues arising in terms of sexual misconduct. And as we recall, Op Honor was initiated by an operations order that was dated in 14 August 2015, and was subsequently amplified by certain fragmentary orders or fragos. And I think that's the first problem, because, and I've commented on this before publicly, that by trying to implement a personnel policy and a disciplinary policy using an operation order, although that sounds really inventive and it sounds particularly clever, I would suggest that it's particularly problematic, because as we all know, operations have a finite termination point. You have to have an achievable outcome in order to conduct an operation. And even the former chief of the defense staff, John Vance, acknowledged that achieving the end state for op honor was frankly not possible. It was an aspirational goal. That being the case, I would suggest it never should have been made an operation order. It should have been made a policy just like any other policy. And we'll be returning to the problem arising from misconceptions about op honor in a few short moments. One of the things that was created in response to the Deschamps report was the Sexual Misconduct Reporting Center. And frankly, a lot of people, I would suggest, don't fully and still do not fully understand what the role of the Sexual Misconduct Reporting Center was and is. And in fact, if some of you turn your mind back to the testimony before the Standing Committee on National Defense that Lieutenant Commander Trotter gave several weeks ago, I found it singularly problematic that when Lieutenant Commander Trotter contacted the SMRC for guidance on what to do, the guidance that he received from somebody at the Sexual Misconduct Reporting Center and from somebody in presumably the office of the Deputy Minister, that guidance was actually incorrect. And one has to wonder whether an institution is going to be effective if people do not understand what the role of that institution is, and if some of the people functioning with that institution do not fully understand what their role is. And in fact, very recently, Liberal MPs within the Standing Committee on National Defense have suggested that they want to see the Sexual Misconduct Reporting Center become the, quote, primary reporting resource for criminal and non-criminal sexual misconduct. And frankly, that is a patently ludicrous suggestion. And I might be offending some people by suggesting that, but the reality is the Sexual Misconduct Reporting Center is not equipped nor capable of being the principal reporting resource for criminal misconduct. And in fact, the Canadian Forces already has a relatively robust institution for doing that. It's called the military police. Now, one of the things that came to light in op honor was the so-called duty to report. And this can be traced back to QRNO articles 4.02 for officers and 5.01 for non-commissioned members. This is nothing new. Those provisions have existed for years. And a lot is said about the duty to report. But essentially, when we look at the duty to report, what we're really dealing with here is a leadership function, because those QRNO articles do not deal solely with the duty to report. If you look at the context in which those provisions and the duty to report are found, the emphasis is placed upon personnel in leadership positions taking appropriate action to solve a problem. And if somebody doesn't have the authority or the leadership capacity to solve the problem, then that's where the duty to report arises. They need to report it to somebody who can. Now, I promised before that we'd return to the issue of misconceptions arising from op honor. And one of the best examples that I can give you is from a case, the Queen and Banting from 2019, in which the presiding military judge, Commander Suchsdorf, provided at paragraphs 28 and 29 a clear description of what people were misconstruing about op honor. And what I'll preface this with is a comment that quite often in my practice, both when I was still in uniform and now in private practice, I encountered repeatedly people talking about Corporal Bloggins or Captain Smith violated op honor. And that was in fact not actually the case, because op honor did not describe offenses. It did not describe prohibited conduct. Those were already described in existing orders, in existing DAODs, and existing instructions. What op honor did was it created an obligation and it created a structure for the chain of command in dealing with those infractions. And so whenever you hear people saying so-and-so violated op honor, that simply wasn't the case. And it becomes a lazy kind of shorthand. And that leads to people not fully understanding what it is that they are faulting an individual with respect to their misconduct. And so what Commander Suchsdorf wrote in the Queen and Banting was as follows. CDS order op honor dated 14 August 2015 is a cornerstone document that will become a legacy of its time. And it's already, quite frankly, become a legacy. It has made more of an impression on leadership, instituting overall change in behavior than other documents of its kind. Although it is clear that op honor is written as an operation order, it is in substance a policy directive issued to the chain of command describing how it must handle reported incidents of misconduct and sets out tasks, including the chain of command's responsibility to institute proactive and preventative policies. The CDS op order defines the problem, sets out the CDS's intent, describes the lines of effort, the conduct of operations, and provides extensive direction on tasks and support requirements. In many ways, it is an effective tool to accomplish the CDS's intent. Now, quite frankly, I think Commander Suchsdorf was being generous. I'm not too sure it was all that effective a tool. And one of my misgivings about op honor was that it misled people into thinking that op honor actually created prohibited conduct. When in reality, what op honor was direction to the chain of command. The only way somebody could, quote unquote, violate op honor is by not, as a member of the chain of command, by not following the directives thereunder. And what we saw under op honor were a variety of responses under both the Code of Service Discipline and administrative measures. And what I'd suggest to all of you this evening is that the administrative measures over the last 6 years were far more frequent than measures under the Code of Service Discipline. And I'll be blunt. I would suggest that the main reason that the principal response to sexual misconduct over the past 6 years was under administrative measures rather than the Code of Service Discipline is because increasingly the chain of command has lost confidence in the Code of Service Discipline. Whether or not they're justified in losing confidence is another issue. But I would suggest that one of the principal problems that we have encountered time and again is the recourse to administrative measures instead of the Code of Service Discipline. And certain members of the Canadian Forces have been told that their misconduct was so egregious that the sole appropriate response would be to terminate their service in the Canadian Forces. The problem that I have with that is that if the misconduct were so egregious that it warranted the termination of an individual service with the Canadian Forces, then why was it not sufficiently egregious to warrant charges under the Code of Service Discipline? Next, we'll get to roles and responsibilities, and we'll go over this relatively quickly so we can get into our Q&A as the evening progresses. There are a variety of people that have specific roles and responsibilities in dealing not just with sexual misconduct, but dealing also with misconduct in general in the Canadian Forces. And we're not dealing just with the Code of Service Discipline. We're dealing with any form of misconduct. And it extends all the way up to the Minister of National Defense. And I've listed various actors in that list. And one thing I would suggest to all of you is that when we look at those names and the various roles and responsibilities that they'd have, the one common thread is that they are all exercising predominantly statutory powers. Now, with the Minister of National Defense, there's also some constitutional functions, but in reality, all of the people that you see on that list are in effect exercising statutory powers when they are dealing with sexual misconduct. And what that means is, in keeping with the theme of the rule of law, as statutory public law actors, those individuals must, A, provide procedural fairness in the decision-making where it significantly affects the rights, interests, and privileges of the subject of the decision. They must make decisions that are rational and reasonable, and they must justify those decisions. Now, not all decisions are going to require the same of what we call the content of fairness. The content of fairness will vary based upon the nature of the decision being made and the process followed in making it, the nature of the statutory scheme and the term of the statute pursuant to which the body operates, the importance of the decision to the individual or the individuals affected, the legitimate expectations of the person who is affected, and the choice of the procedure by the statutory decision maker, him or herself. But when we are dealing with significant decisions, such as the compulsory termination of service in the Canadian Forces, the content of fairness will be high, which means those statutory decision makers must provide for a procedurally fair, substantively reasonable, and justified decision when they're exercising those powers. If they do not, they open themselves up to be challenged for failing to do so. In many cases, that will then turn to the Canadian Forces grievance process, and we'll talk about that in a moment. But in some cases, and we've already seen at least one example of this, it could lead to litigation. And what I'd suggest to all of you is when we look at the roles and responsibilities of the various statutory decision makers that have to play a fundamental role in addressing sexual misconduct, we are not dealing solely with the Code of Service Discipline. We are not dealing solely with administrative measures. There are a broad variety of issues that are going to come into play. That includes effective training for statutory decision makers. And I would suggest to you that this is one area in which the Canadian Forces regularly and consistently falls flat. There's very good training for decision makers when it comes to the law of armed conflict. There's very good training when it comes to decision making at the summary trial level of the Code of Service Discipline. But there is very little training for decision makers who exercise the broad and comprehensive public and administrative powers that are given to various statutory decision makers under the National Defence Act. The data collection when it comes to sexual misconduct has been inconsistent. The analysis has been inconsistent, and probably the most significant failure, I would suggest, is the lack of available data to the public, to scholars like myself, to offer commentary on whether or not the Canadian Forces is achieving its end state. We've talked a fair bit about the Code of Service Discipline, and I won't belabor that particular point because we want to get to some other issues as we progress along. And as I mentioned before, one of the trends that I have noted over the past 6 years is that increasingly administrative measures are being used, often where the Code of Service Discipline is not applied. We also have to question whether or not administrative measures ought to be taken before the Code of Service Discipline or a criminal prosecution has run its course. I do want to offer a word or two on independence because a great deal has been said about independence and most of it's been misleading or incorrect. Whenever I hear somebody talk about the need for somebody to be an independent actor, and there's been a great deal of discussion about that over the past several weeks, the first question I ask is independence from whom? And the second question I ask is to what extent? Because there's a great deal of independence that is exercised by various statutory actors and decision makers under the Code of Service Discipline. However, it is not absolute independence. It's not independence similar to judicial independence, which we see in both military and civilian judges. And judicial independence has three general hallmarks. One is security of tenure, the second is financial security, and the third is institutional independence. And most statutory decision makers under the National Defence Act do not have the same security of tenure that a judge has. Certainly, we've seen that with several general officers who have been removed from their position. They do not have the financial security that military judges or civilian judges have, nor do they have the same institutional independence. In fact, various actors that insist that they're independent, such as the Military Grievances External Review Committee or the Military Police Complaints Commission, while they have a degree of institutional independence, they do not have the security of tenure or the financial security that judges have. They are not remotely close to being as independent as judges are. And one of the reasons why various statutory decision makers are not as independent as judges is because there is generally an indirect relationship between independence and accountability. And I would suggest to you that one of the biggest concerns that we all have in addressing sexual misconduct is the need for accountability of decision makers. And the more independent a decision maker is, the more difficult and the more limited the scope of accountability that is brought to bear. For example, judges are generally held accountable by one of two institutions. a civilian judge who comports him or herself in an improper fashion could find themselves in rare circumstances brought before the Canadian Judicial Council. For military judges, a similar body is the Military Judges Inquiry Committee, but that happens relatively rarely. The most frequent term of accountability for judges is when an appellate court reviews their decision. But that's what I mean by a limited scope of accountability. With statutory decision makers under the National Defence Act, there's a higher level of accountability, and therefore it would be problematic if they had too much independence. Finally, many of you will have already reviewed some information involving the third independent review of the National Defence Act that was recently released on the 1st of June. This was conducted by Justice Morris Fish. Now, the way that the third independent review, or IRA3 is the shorthand that you'll often see, the way that that differs from the Deschamps report, or now the Arbor report, or the Arbor inquiry, is that the independent reviews are mandated under the National Defence Act. They are obligatory. The Minister of National Defence is obliged to have them conducted. The previous reviews that were conducted by the Chief Justice, the late Chief Justice Antonio Lemaire in 2003, and by Justice Patrick Lesage in 2012, were actually conducted by virtue of Bill C-25. They were conducted every 5 years, but if you look at the dates, you'll note that there was far more than 5 years between the review conducted by Chief Justice Lemaire and the review conducted by Justice Patrick Lesage. Now, under the National Defence Act, the reviews are conducted every 7 years, and that's why Justice Fish conducted his starting in 2020. The third independent review ran to 400 pages. There were 5 chapters in the review, and you'll see them up there. What I found interesting is, even though we're talking about a 400-page review with 107 recommendations, the only thing that you heard in the news media was about sexual misconduct. And the chapter on sexual misconduct ran to 15 pages. The third independent review was about so much more than sexual misconduct. It was about military justice writ large, and by that I mean far more than just the Code of Service Discipline. There was an opportunity lost for public discourse about the improvement to military justice in the Canadian Forces because all anyone wanted to talk about was sexual misconduct. Now, we heard that the Minister of National Defence agreed in principle with the recommendations, but so what? They agreed in principle with the Deschamps report, and that didn't necessarily lead to success. Moreover, the Minister of National Defence committed to begin implementation of only 36 of the recommendations, and most of those recommendations were not particularly difficult to implement. The more challenging recommendations were not included in the list for immediate implementation. There were certain key themes, and you'll see them listed up there, that I want to draw for your attention from the third independent review. One was that the military justice system, as a justice system, should continue. But note that the military justice system is not expected, nor should it, simply mirror the civilian justice system. Because again, if we go back to Genereux, the reason we have a military justice system at all, or a code of service discipline, is to assist in maintaining the discipline, efficiency, and morale of the Canadian Forces. The other thing I want you to draw from this, because it applies not just to the recommendations that Justice Fish made, but in fact to any reform of any aspect of governance of the Canadian Forces, and that is piecemeal reforms and quick fixes are not sufficient. They are rarely sufficient. If you're going to change something, you have to take a comprehensive approach, and it has to be both deliberative and deliberate. And ultimately, when people like to point to the independent review, they say, well, you have to do this. We have to remember that what Justice Fish is recommending, much like his predecessors, is not that which must be done in order to comply with the Constitution, for example, but is an ideal system. In other words, it is an aspirational recommendation. These aren't the only conclusions that can be drawn from the third independent review, but they are key select conclusions. One of which, and these were not included in the 36 that the Minister of National Defence suggested would be subject to immediate implementation. was a significant reform of the military judiciary, and in particular, the creation of a permanent military court. One of the themes that was stressed throughout the 400-page report was the need for transparency, security of tenure of key positions, and institutional independence of key positions. But again, I suggest that we have to balance that with accountability. The third, and this is vital when we talk about sexual misconduct, is the ongoing need for collection of meaningful data, transparent publication of that data, and ongoing analysis. There are no fewer than 8 significant recommendations within the report that all deal with the collection, publication, and analysis of data. Because if we are going to reform the governance of the Canadian Forces, it has to be principle-based and therefore has to be based upon cogent evidence. That's where the data collection comes in. And we have to remember ultimately that military justice, not just the Code of Service Discipline, but military justice writ large, has to serve the needs of discipline, efficiency, and morale. And the one thing I'd leave you with respect to the third independent review, is this should not be taken as the final word. This should not be taken as done and dusted. These are all the recommendations, implement all the recommendations, and we're golden. This is, and I'm pretty sure Justice Fish would agree with me, is a start state. There are 8 recommendations for convening or continuing with working groups to further analyze certain difficult and complex problems. Justice Fish compiled his report over the course of approximately 6 or 7 months. And one of the first things he acknowledged was that he is not an expert in the military justice system. He's not an expert in the Canadian Forces. What he is providing is a framework by which further reform can be followed based upon better collection of data, better analysis, and continued examination of how we can improve. So I'm going to talk a little bit about the Arbor report, but not a lot, because quite frankly, we're still in early stages. In fact, it was only today that the announcement went out for submissions to Justice Arbor and her team. One thing I would suggest is that obviously it's going to focus on sexual misconduct. What I'd like to see, however, is that report and that analysis framed within the broader issues of governance of the Canadian Forces and military justice writ large. And to a large extent, I would suggest that certain passages, particularly the second chapter of the third independent review by Justice Fish, was essentially a layup to Justice Arbor. Justice Fish was, in my view, quite clearly providing a platform or a springboard from which Justice Arbor could carry on her work. And what I would like to see personally is taking the issue of sexual misconduct and placing it within the broader framework of governance of the Canadian Forces, the unique nature of the Crown-Soldier relationship, and how we deal with military justice writ large. Because if we only seek to solve the issue of sexual misconduct, absent any other form of misconduct, then we're not actually solving the problem. We're not actually addressing the disease, we're merely addressing the symptom. And so the key conclusions that I want to offer you this evening is, first off, the solution to sexual misconduct is not a single factor. It is not based solely upon the Code of Service Discipline. It is not based solely upon administrative measures. It's not based solely upon training. But all of those factors form a broader solution to the issue. And it is not just an issue of sexual misconduct, but how do we deal with misconduct generally? How do we deal with impunity within the context of the Canadian Forces? And you'll see there I've offered a list, and it is by no means an exhaustive list, of certain considerations for how we can achieve success in addressing sexual misconduct. Again, to reiterate the comment that Justice Arbor made, piecemeal reforms and quick fixes are not sufficient. They are not the solution. And no matter what outcomes we reach for, success will necessarily be judged upon the extent to which we respect the rule of law.
A really, really good, detailed and in-depth education for us. I think we're a group of experienced people. We realize that on the surface of these issues, there are far more complex structures and paradigms and factors that go into why things are the way they are. And people are generally looking to find a simple solution to very complex problems, often exacerbated, of course, by the media, but that's the media's role, is to keep things top of mind. So thanks very much, Rory, for that. I think it was extremely worthwhile for us, and will be extremely worthwhile for all who choose to download that, have a look at that video in the RCMI YouTube channel. So these presentations go much further afield than just the folks who are with us tonight, but we always appreciate their participation, of course. Let me thank, in addition to you, Rory, let me thank Sylvia Lau, who is always there supporting all of these activities. I'm sure this is a skill set she probably didn't imagine she would gain a year and a half ago, but she's done a magnificent job with all of these virtual presentations and all the different variations. And of course, my confrere Eric Morse, responsible for communications, etc., in the RCMI, does a great job. So really, it's a team effort for sure. Let me end, if I may, by again letting you know that we will not be holding presentations in the months of in July or August, but we will be back in September. And on September 16th, we have Dr. Barbara Perry, who's an expert in right-wing extremism, and we'll be talking about right-wing extremism in the Canadian Armed Forces. And in October, we have Dr. Richard Chmulka from the Macdonald-Laurier Institute. It's going to give us a snapshot of how Canada-US defense relations have shifted in the post-Trump environment. So I think both of those presentations will be very, very interesting. On behalf of the RCMI and on behalf of my committee, the Defense and Security Studies Program, everybody in attendance here tonight, the staff, Sylvia, Eric, Rory, thanks again. And we look forward to having you in person at the Long Bar sooner rather than later. I think we're getting close.
That would be great, Dan. I'm looking forward to getting back to the RCMI. It's been a long time.
So are we, as well as everybody that's online. We'll crowd in there as soon as we can. So with that, thank you very much for attending tonight. Appreciate it, and we'll see you soon. Take care. Stay safe.
This has been another in our series of webcasts produced by the Royal Canadian Military Institute in Toronto as a public educational service. You can find news of upcoming events and links to our webcast archives at www.rcmi.org. On behalf of the RCMI, this is Eric Morse saying goodbye for now, and thank you for joining us.